This is immigration attorney Parviz Malakouti. I recently had a case with a dreamer. It was a married couple in which we applied for adjustment of status for the dreamer on a marriage-based application based on her marriage to a U.S. citizen. And I thought this is an illustrative case of a common issue that comes up with a lot of dreamers. So we were successful. I represented the client from start to finish, and I attended the interview. Great couple, the dreamer from a Latin American country, not Mexico, and of course her husband from here in the United States. We applied for adjustment of status. We went through the process. We didn't get any requests for evidence. It culminated in an interview. I attended the interview, prepared them for it. Interview went well, and we actually had the green card within a week, which is very quick. But this applicant, this dreamer, had applied for adjustment of status previously and been denied. She had applied about 5 years ago for adjustment of status. She had a little bit of a messy immigration history, but she was denied adjustment of status 5 years ago, but she was approved recently. So why is that? That's what I want to go over in this video. And what had happened here is that her previous application for adjustment of status had been based on being the daughter of a legal permanent resident. So her mother had gotten legal permanent residence and then applied, petitioned for her, for a green card for her. The problem is this dreamer, my client, as well as all dreamers, is not in a period of immigration status. She has no immigration status. Now this is kind of a complicated situation or a complicated topic because a lot of dreamers and DACA recipients think they have immigration status. No, technically DACA recipients do not have immigration status. They're in a period of authorized stay. So it means they're allowed to stay in the country, but they don't have this thing called immigration status, which is a legally loaded term that means a very specific thing. If you don't have legal status, immigration status, as a general matter, you're not allowed to adjust status. That's what's called a bar to adjustment of status. So she was denied her previous adjustment of status application because she was not in immigration status. She also was not in immigration status recently, and that was a bar to her adjustment of status. Now, why were we able to successfully adjust status for her recently and get the green card for her? That's because there's an exception to that rule that if you don't have immigration status, you can't adjust status. And that exception is if you are an immediate relative of a U.S. citizen. Now, immediate relative doesn't mean everything. It doesn't mean an uncle, it doesn't mean a cousin. It has a very specific definition, and it means if you are the spouse of a U.S. citizen, if you are the child of a U.S. citizen and you're under 21 years old, or if you are the parent of a U.S. citizen and your child is under 21 years old. So my client, the dreamer, married her husband in the interim. Okay, she married a U.S. citizen, and because of that marriage, that relationship made her an immediate relative. Okay, and so we were able to apply for her successfully for adjustment of status. Now, this case had a few other small issues, not big issues, small issues related to her previous immigration status that had to be, or her immigration history, which had to be cleaned up. They had applied for consular processing actually at a consulate abroad in another Latin American country, and then they had canceled that request, tried to move it in for adjustment of status. It was a little bit messy, but nothing that was insurmountable if she was represented by a qualified attorney. So we were able to get that for her. And I think this case kind of illustrates the issue that a lot of dreamers have, as I mentioned. One other important fact is that she was able to adjust status based on this because she had entered with a visa. She entered as a derivative of a principal applicant for a work visa. She came in, she overstayed that visa, okay, obviously, but she did have entry with inspection. That's an important point for dreamers that are looking to adjust status because while there are exceptions and exceptions to exceptions, the general rule that you start off with is that if somebody comes in, enters the United States without inspection, they can't adjust status within the United States, unless, of course, they fall into one of these other exceptions, whether it be advanced parole, military parole in place, I-245I petitions, and a few others as well. So anyway, that was it. That was a happy story. I thought I'd just drop this story because A lot of times it's easy for us, dreamers, anybody, to understand legal concepts if they're presented in the context of an actual scenario, a real story. I think we process the information more easily that way. So that's it for this video. If you have any questions about your particular situation, if you want to apply, if you want to find out if you're eligible to apply to fix immigration status or to get a green card, click on the link below, book a paid consultation. We can go over your situation one-on-one with me, either via Zoom or telephone. And if you don't want to deal with having to figure this out, if you just want to hire an attorney to deal with it, click on that same link below. We can go over the price, timeline, chances of success, and of course, go over any issues that the case may have. So that's it. Good luck.